Good morning, everybody. Congratulations on making it to day 3 of the fest, making it up bright and early this morning. My name is Andy Parrish. I'm the Director of Client Services for Haystack ID, and thank you for coming out for this presentation about best practices from a forensic standpoint in light of a theft of trade secret investigation. With me this morning is Drake Lightly, who's our Director of Managed Review Services, and Michael Sarlo, who's our Vice President of E-Discovery and Forensics. So we'll be passing the mic around for a bit as we kind of divvy this thing up. So a couple of sort of preamble steps. This presentation you're about to take a look at was originally put together primarily for an attorney audience, and it's actually been done for CLE several times. Sadly not this session due to some lateness on everyone's part. But if you're looking for a specifically deep dive into tools and specific methodologies and things like that, I'm afraid you might be a little disappointed. This is going to take a little bit of a higher view towards what we believe counsel should be aware of when they look to investigating a departing employee or potential theft of trade secret. So let's start off with taking a look at really kind of where trade secrets sit in the equation. And courts have used words like ephemeral, elusive, things like that to describe what trade secrets are, and it's hard for people to put their fingers upon it. But ultimately, when you look over what's happened from the last 30 years or so, and you go to companies and you say, well, let's take a look and take sort of a reckoning of where you are assigning your value. And you look 30 years ago and you can see that 83% of their stuff, they said, were actual things, machines, parts, whatever it might be. Fast forward 30 years to 2015, and the model has completely flipped on its head. And now they're saying that almost 9 out of 10 of their most valuable assets are in fact intangible. And those are the things that will fall into the sort of trade secret bucket. So when you look to how the court might define a trade secret, and again, like I said, they've used this sort of flowery language to describe something that says it's basically hard to define. Oops, wait a second. The court is saying that, first of all, it's business information that is subject of a reasonable effort to keep it secret and has some form of economic value from generally being not known publicly. And so they developed a 6-factor test to determine if what you're talking about really qualifies as a trade secret. And so those 6 things are the extent to which it's known outside the company, the extent to which it is known inside the company, what measures have been taken to protect that information, what is the value of that information were it to be made known to competitors, how much time, effort, money, sweat equity was put into the creation of this secret, and ultimately the last one, how difficult would it be for a competitor to replicate or duplicate it? And if you pass those tests, then you've got a bona fide trade secret. If you don't pass all those tests, then you may not. So let's take a look at this. This is just a fun thing. So paint a picture of, you've got a client that's got source code, which is pretty easy to understand in terms of its secrecy, and then you've got your grandmother's cookie recipe. And Grandma's cookies are a big hit inside the office, and everybody loves them, and there's a tip jar left out there, and it makes a little bit of money. But when you look at this and you put it across that 6-factor test, how valuable or how well known is it outside of the organization? And Grandma's cookies are famous the world over, apparently, or at least the neighborhood over. So, and she doesn't necessarily want to share that all over the place. So that's going to get a high score of a 5. Source code obviously is going to get the 5. But then you look out across the rest of the things. Inside the organization, everybody knows the recipes to Grandma's cookies. Everybody knows that there hasn't been a lot of measures taken to keep them a secret. The value of it isn't really all that special. It's just a recipe for chocolate chip cookies. There hasn't been a significant amount of investment in it, and it wouldn't be terribly difficult for a competitor if they wanted to duplicate that cookie recipe. But the source code, on the other hand, across the board would be exceptionally difficult to duplicate, exceptionally valuable, not well known inside or outside the organization. There have been significant measures taken to protect the secrecy of that source code. And what we generally tell our clients is there's an important role for both in-house and certainly outside counsel to play in terms of being able to maintain your privilege when you're doing these investigations. And when we get into talking about what goes into the investigation, we're going to talk a little bit about trying to avoid the temptation, which is present everywhere, to do your own sort of poking around and investigation or reconnaissance into what you might be looking at. That's not a smart thing to do. You might end up with some kind of waiver as a result of that. So, where does it normally come from? And it's generally either from data breaches, and we all have seen this all over the news. That's a separate discussion. We could talk all day about cyber and data breaches. What we're really going to focus on more in this session is going to be around departing employees, which is really what, in our experience, one of the largest culprits in terms of either intentionally or not, I shouldn't say intentionally or disintentionally, but maybe not with so much malice, or perhaps with malice aforethought, of taking things from their prior company. So take a look at, take a look at some of these stats. So 50% of people who are leaving their prior employer are taking what ultimately could be argued successfully to be confidential company information from that prior employee. 40% of those people plan to use that information in their new job. And this is the big one. 44% of people who believe that a software developer who made something for company A and moves over to company B believe that that developer has some pride of authorship or ownership of that code or that product that was developed for company A. And that's not, unless there's a contract that says that in their employment agreement when they worked for company A, that's just not the case. So how are we finding things in terms of where this happens? And there's a lot of creative ways to go about trying to abscond with company secrets or misappropriate it. But these are some of the most typical ones. We frequently are finding people attaching and sending documents and trade secrets, whatever they may be, to personal email accounts from their work computer. I'm going to grab it from the network, I'm going to attach it to an email on my Gmail account, and I'm going to send it myself, and no one's ever going to know. We hear that a lot, and it's flat out wrong because, of course, we can find that very quickly. Copying things to external USB devices. I'm just going to move it off to this device, and I'm going to keep it in my pocket and never bring it back to work. No one will ever know. There's ways that we can find that as well. Uploading trade secrets to cloud storage accounts. I'm going to move everything over to my personal OneDrive. I'm going to move everything up to Dropbox. Again, every action that is being taken on these computers, largely anyway, is leaving a trail of breadcrumbs, and it is therefore auditable and findable. Bulk exporting of trade secret data from cloud-based business systems. We actually just had a case where the target of the investigation had been very good about covering his tracks, and he had given notice on a Friday and was scheduled to come in on the following Monday to turn in his devices. And when we looked at his devices, they were largely clean, but one of the things that we did find was that on the Sunday, so 24 hours before he turned in his devices, he had downloaded 4,000 files, all very protected, from a corporate OneDrive account, and had failed to disclose that he had done that. So that put him in some hot water, obviously. And then lastly, Apple iCloud accounts, similar to what we're talking about with the cloud storage. There is a lot of places, and this can be a place where a lot of people are not necessarily are mindful of this. So if I take my phone and I leave my job and I go get a brand new phone, and I have synced everything on this phone back to my iCloud account, and my company has not been smart enough to disable or suspend that, or hasn't put in mobile device management to preclude me from doing that. I get my new phone now that I'm free from under this company phone. I log into my Apple iCloud account and I download everything that this phone had synced up to the iCloud. And suddenly I have all the content that I might have had on this, which, as we all know, this is now just a supercomputer, right? When we were all, at least a lot of you are younger than I am, but when we were kids, this would have filled up an entire room in some warehouse. Now it's in our pockets. So there's a lot of different ways that people can get to this data, and there's a lot of steps, I think, that companies can take to prophylactically make that much more difficult. And certainly in response to this, there's ways that we can get going in terms of mitigating that risk. So in terms of how an investigation might start, generally it starts off with somebody smelling some smoke, right? And the question becomes, is there smoke or is there fire? So the first things that need to be done, because we're all going to play by the rules on this, is to identify and preserve any data or any devices that may ultimately be the subject of this investigation. So, again, evidence is super transitive, it's ephemeral, it's fragile, and we use the analogy of it's ripe fruit. And if it's not picked, it can very easily wither and die, or at least change to something that becomes less friendly. So when you are taking these steps to start to put together your list of potential targets and devices and things like this, the biggest piece of advice that we can give people is to document this stuff up one side and down the other. It is hugely important that you have a very robust and auditable and kind of extensible paper trail that you can use that tracks every step in this. I think anybody who's been practicing law, at least in the last 5 or 6 years, can attest to the significant uptick in the amount of discovery about discovery, right? I mean, I think I do another class where I've got metrics for it, and I think the number was about 42% year over year uptick in motion practice, challenging the methodology around which was the methodology used for this sort of collection work. So having a documented piece of process here is a major piece for us. So some critical dates, and we're going to talk a bit about an evidence map. And an evidence map, long story short, is really a very robust and sort of complete reckoning, typically in an Excel spreadsheet, of everything that's been done. But some critical dates that we need to know, because these make a big difference for us. So for a departing employee, what was the last date of employment? What was the last date of employment at the plaintiff organization? What was the defendant's first official date at the new organization? And what was the date and time that the company turned in those devices? All of these things, all the analysis that we can do based upon the data that we can collect, we can then timeline human behavior and human activity across this. So knowing these dates makes a big difference. Remember that story I told you about the guy who pulled down 4,000 files from the OneDrive, right? Had IT at his prior company, upon receiving his notice, immediately suspended his access to all those corporate systems and his mail and everything else, he would not have been able to get to that data. But they didn't do that. They waited until they got the devices back, and then they were going to turn it off, and by then, you're locking the door after the cow's already gotten out. So, what is this? Are you pushing something? So, knowing the last date and time of a former employee had control over the computer will allow the examiner and your counsel to efficiently focus on what activities we need to take a look at, and that's an important piece of where this all goes to. So another analogy we use when we talk about this is sort of the ER doctor versus the surgeon, or versus a more specialized doctor. So, like I said, the question is, I've smelled smoke. Is there now fire? And I need to check that out. So think of the forensic examiner as being an ER doctor. So you show up at the ER and you say, "Doc, my chest hurts. I can't breathe." All right, well, there's a few things that could happen, and there's going to be a battery of standard tests that are going to be run regardless, right? Now, certainly when you say, "I can't breathe and my chest hurts," you're going to get an EKG, and they're going to start thinking that maybe you've got having a heart attack or you have heart failure. You could just as easily have really bad indigestion. You could have a bad case of gas, right? But they're going to do those tests, and they're going to treat it that way, and that's kind of what we're saying the initial investigation should be looking at. So taking all of this stuff and taking these sort of prescribed steps to preserve all this data and to do some initial analysis against this data is that initial diagnosis. At that point, you can engage specialized counsel. And again, this isn't just any old counsel. This is counsel that knows what they're doing and understands how this all works, to work cooperatively and jointly with the forensic examiner to actually diagnose whether that smoke was just a whiff on the wind or whether there is actually a fire. Does that make sense to everybody? Good. So, a couple of steps around defining what's a win, and this is one of the steps that we generally take with our clients when we first meet with them, is sort of like most process-driven organizations, we want you to start at the end, and we'll reverse engineer back. So really the question for the attorneys is, what is a win? What is it that you're seeking to gain? And so you look at these two things. From a plaintiff perspective, you want to obviously protect the business, you want to retain all your customer relationships, you want to be able to make sure that this departing employee is not going to make off with anything that you have spent significant time, effort, money, and resources to protect or to develop. From the defendant's standpoint, he just wants to get free and clear of wherever he is, have a clear rules of engagement, in terms of engagement, in terms of a go, no-go list, geographic and time boundaries and things like that. So the question that we put to the client then is what are you looking to do? Are you looking to, is there a need to be punitive here? Is there a need to go great guns at this? Or are you simply looking to remediate this situation so that everybody can get on with their lives? And those two, in our opinion, these two things are not diametrically opposed. They're both a win, all right? But it all depends on the nature of the case. So I'm going to turn this over now to Drake, and he's going to talk a little bit about some of the federal law that's going on, some of the steps that can be put in place by counsel and by organizations to help mitigate and sort of preventively or prophylactically avoid some of these problems, or at least put yourself in a much better defensible position should your organization come into that.
Well, once you've determined that you do have an issue and you do need to take action, it's really, really important that you determine what your objective is. If you do not, it can become a very expensive proposition, and it could result in counterclaims, which could backfire in your effort. So as the plaintiff corporation, you really are seeking to do one thing. You're seeking to protect your business interests. So you're looking to make sure that you haven't lost any customers, you haven't lost any trade secrets, you haven't lost anything that's going to cause you to have a less competitive advantage in the marketplace. As the leaving the departed employee, your goal is pretty simple. You just want to make sure that you understand what you can do to not get sued, what you can do. That's usually pretty simple. You would negotiate a customer list of the customers with whom you'd had substantial material contact with, which would give you insight, the geographical area that would be implicated there, the time frame which you would be precluded from having contact with those customers, and that should give you enough of a definition that if you stayed within the parameters of that agreement, you should be free from lawsuit. Um, the DTSA, crap, why is this just jumps around. The DTSA, the Defend Trade Secrets Act of 2016, was an effort to define this really amorphous term that meant different things to different companies doing different things. But broadly, it relates to financial, business, scientific, technical, economic, or engineering information. And it can be as, patterns, plans, compilations, program devices, formulas, designs, prototypes, methods, techniques, processes, procedures, programs, or codes. It can be anything from a business process to, a very hyper-technical design. Anything that would have use in developing or marketing your product or your service. It doesn't matter how it's stored, compiled, or memorialized. It could be a memoranda. It could be a PowerPoint presentation. It could be, scratchings on a napkin. The way that it could be have left your company unauthorized, it could be attached to an email. It could be a photograph taken on a cell phone. Forensic capturing of images from cell phones of departed employees is probably pretty important, because if they thought that they might get caught on email, they might have taken a picture. But in order for those types of information, you have to have taken reasonable measures to keep the information secret. Meaning it can't be stuff that you had on marketing slicks that you left behind. You can't have presented the information at seminars or sales calls unless it was subject to an NDA. You had to keep it secret, and the information has to have an economic value, because if there's no damage for the information leaving, then there's really no cause of action. So it has to have a financial implication, or the courts don't care. There's the potential that your departed employee may have engaged in fraud, as defined by federal law, if they used or they previously had authorized access, but they became unauthorized either by change of employment status. So if they continued to access a database or information after the termination of their employment, if their credentials weren't timely terminated, or if their job title changed, or if there's simply language in a contract that said, that you're unauthorized to access this information for other than business purposes of furthering the business of the corporation. So accessing it for your future employment is certainly unauthorized access. Examples would be the former employer takes reasonable steps to protect the company information. Then somebody accesses information on a computer, copies it. They didn't have a right to access. It wasn't part of their job description, and then they delete it. So they've taken it for the benefit of their future employer, and then deprived the former employer with all the value of it. So that would be the most egregious extreme. More likely, you're likely to see an instance where somebody who had authorization took the information and left it intact, but they took it simply so that they would have talking points with their new employer to make them competitive about whatever area of expertise they were taking to their new employer. So a win is potentially an injunctive relief, a temporary restraining order, just a restraining order to prevent foreseeable harm while the facts at issue are gathered and assessed. So while you're in the investigative stage, you would either seek a court order or a voluntary agreement that there would be a cessation of activity that would rely on that type of information. So your impacted employee would, if it was a salesperson, they would be precluded from going out and making sales calls until this got resolved. If it was a programmer, they would be precluded from programming for you. So it can be temporary or it can be a mandatory injunction or for specific performance to restrain or remediate threatened harm. That could be something like requiring somebody to turn over their personal computers, to allow their computers or their devices to be forensically imaged, to preserve evidence, to actually to prevent them from going to a workplace. It could be anything to prevent them from actually having even an opportunity to use the information in any way. And it could even go to a permanent injunction, which is essentially termination of the employee and that had just left, so they lose their job at the new place. The existence of an enforceable restrictive covenant can improve the chances of achieving a permanent injunction. So when you're onboarding employees, if you have the information that they're going to be exposed to, that would represent a risk to your company if they left, you will definitely want to have a restrictive covenant that will prevent them from taking information in the future, and that would subject them to injunctive relief. In many places, they're not enforceable. California is a place where it's very difficult to enforce any of these types of things, except for those that are covered by the federal statutes, where it's improper use to cause business harm. States vary quite a bit in their restrictiveness.
So is anybody here local? Any attorneys in here local? Chicago or Illinois? No? Okay, so this slide here, when you look at sort of that last bullet, the reliable versus, and I'll never pronounce the name correctly, but essentially this was an interesting case because essentially what it said was, and what it did was it reset about 30 years of precedent. The case basically pivoted around reliable makes fire suppression and fire detection equipment, smoke alarms, fire extinguishers, things like that. And they hired Arredondo as a salesperson. And Mr. Arredondo built up a book of business and eventually decided to split out and form his own company. And Reliable filed suit that this was in theft of trade secrets, largely because within Illinois, one of the things that the state court at least, has long held is that near permanent relationships, that's an important phrase in Illinois, near permanent relationships are a protectable interest. And Reliable was making the case that they had formed such relationships and that Mr. Arredondo had infringed upon those and was taking them with him. And ultimately what ended up happening in this decision was Arredondo claimed that the covenant was not enforceable, and the circuit court found in favor of him, agreed. It went to appeal. The appellate court found in favor, and ultimately it was appealed all the way to the Illinois Supreme Court, who promptly, in a fairly divided decision, but reset 30 years of precedent and said, when looking at a theft of trade secret claim and whether a restrictive covenant is in fact enforceable in regards to that, you need to look at the totality of the events. So there's still the same test that we talked about in terms of what's protectable, what's not protectable, but you need to look at the full totality of events surrounding the incident or the action and look at that in context, and then also apply restrictions such as time and place. So now you're starting to see a lot of covenants coming out that are saying, Drake, you can't go work on accounts A through X within this date range and this geography for this period of time. And that's largely built on the back of this decision. So it's an interesting decision. To the extent that you have restrictive covenants, again, advice to counsel is always, it's different in every state. Drake brought up California, the People's Republic of California, right? There's not a lot you can do there. You go to Illinois, much more employer-friendly state. New York, a little bit more employer-friendly. So it's very, very important. And the message really from this case law and really this slide is for counsel to take very concrete and deliberate steps to be as specific and limiting as possible on what you're going to build into a restrictive covenant. The broader it is, the more play and the more flex there may be in there, the more the challenge is going to be made that this is not enforceable, or I'm looking at a facet that is defensible on this, and therefore, Judge, this is not enforceable because this interpretation is reasonable and you agree with me, and therefore I'm free and clear to do whatever I want to do. So just a word to the wise. Sorry.
That's right. So the takeaway from that, though, is that even if you do not have restrictive covenants, some states will essentially give you equitable relief. So if you don't have contractual remedies available, if it's egregious enough, improper misappropriation was the test there, meaning it wasn't just in the ordinary course of performance of their job they got that information, but they had taken affirmative steps to gain information to use improperly. So even though there wasn't a restrictive covenant, equity kind of required that that would be the outcome. If it had just been in the ordinary course of business, the individual got pricing information or had privity to contractual terms, it's a lot less likely the court would have ruled that the lack of a restrictive covenant was enough, was going to make an issue. It would really have required a restrictive covenant if it was just the ordinary information obtained ordinarily in the course of business.
Okay, so can I get that? Thank you. All right, so this is my favorite Dilbert ever. I don't know if you all went to the judicial panel. It's always my favorite part of Relativity Fest every year. Rockstar judges and Judge Scheinlin, who obviously wasn't there, but she's the grand poobah of it, and clearly this is said in sort of a writ large way. It should be abundantly clear that the duty to preserve means what it says, and that failure to preserve and to search in the right places will inevitably result in spoliation. So that was Pension versus Bank of America, a huge seminal case, right? And, again, love the Dilbert. So a couple things. Once we get down to sort of, okay, I think maybe I've seen a flicker of fire, or certainly the smoke is getting a little thicker, we need to do something. So let's talk about, what are first steps? Obviously, first steps are going to be, let's talk about custodians. Where should I be looking? How should I be looking? So, broadly speaking, a custodian is a person with direct knowledge or control of the potentially relevant or irrelevant data or evidence in the underlying matter. There are two different types of custodians. There's probably more than that, but generally in my world there's two. There's the personal custodian, or sort of the worker custodian, and then there's the IT custodian. The IT custodian plays a big, big role here. So again, let's all go back to Judge Scheinlin. Let's go back to Zuba Lake 5, which, believe it or not, is something like 12 years old now, if you can believe that. And let's talk about, her admonishment that not only counsel, but also IT has a role to play in this. And IT has a significant role to play in these sorts of investigations. So, an IT custodian is the IT of the former employer, who can help identify and preserve potentially relevant evidence, not only on individual devices, if that is within a certain risk profile that's acceptable to counsel, and there's plenty of times when you don't want to do that, when you would like to have a third party do that simply to de-risk the deal, but certainly from client-facing or maybe even inwardly facing business systems, your ERP system, your Salesforce system, your ticketing or docketing system, R&D or shared dev stuff, things like that. Places where people have access, the OneDrive that I talked about earlier, that kind of thing, that is going to more likely than not be centrally governed within the IT organization of the former employer. It's important to talk to them. The individual custodian, as I said, that's all of us, right? Sitting around, I've got a computer, I've got a phone, I might have a few external drives. These are all things within my control. So, one other thing about this, has anybody ever heard of an Upjohn letter? Okay, so Everybody remember Upjohn before Pfizer bought them many, many years ago? Okay, big pharma company. And back in the early 80s, there was a case. And basically what the Upjohn letter says, and this is an important piece for counsel again, is the Upjohn letter basically says that the company lawyer or the company's lawyers represent the company. They do not represent the individual employees of the company. So if all of us work for the same company, and Mike is an attorney who's been hired by the company to conduct an investigation, he's going to want to talk to all of us, right? But the first thing he's going to give you is an Upjohn letter that clearly stipulates, I'm going to ask you questions that you are not, there is no attorney-client privilege between you and me. So the answers you give me may be shared with a third party. That third party could be an agency. Could be a governmental agency, could be a law enforcement agency, it could be opposing or whatever it may be. But importantly, Mike's job as the company's lawyer is to protect the company, not necessarily protect the individual employee. So that's an important piece, and generally all of your employment counsel will understand this. And it's become sort of de rigueur. I think everybody is aware of this, but if you're not living and breathing this sort of work day in, day out, it's sort of something that can slip through the cracks. So I'm going to turn this over to Mike, and this is where things get fun, and we put a little bit more meat on the bones in terms of how we actually go about doing this stuff. So, Mike?
Thank you. Sorry, I have a little bit of a cold from so much talking. So there's some basic points of entry, so to speak, as far as when we're looking for evidence and how data would leave an organization or a system. I do this stuff all the time, right? And the first thing we find is that people just copy stuff to a USB drive. Trying not to set an alarm too much can be part of a problem of digging a little bit too deep into these. I always say with digital like forensics, you can just keep going and going and going. Typically speaking, when we're doing an investigation, we're looking for that low-hanging fruit right away. It's something I always tell my clients, right? Everybody thinks you're going to get in there and look at, every corner. Oftentimes, we're looking for the most impactful evidence so we can spend the least amount of money. And that best piece of evidence is usually going to be any type of USBs, a hard drive, a thumb drive that were plugged in to a workstation, a server. I've seen cases where we actually have found, a thumb drive that was plugged into a copy-like machine. An employee was moving data from their computer through the mounted, the mounted networked, copy-like machine, like thumb drive. It's usually pretty common that we see this. When we're doing, IT, custodian, interviews, some basic, questions that we're trying to get a sense of. We're talking to an IT person who is, administering a system that an employee might have had access to, is going to always begin, with the USB ports. Any type of virtual machines. We see this a lot in the software development world and the engineering world. We'll get a laptop or desktop, and we'll find 5 computers, a VM on their local machine, or even more than that, in an actual server. We're always asking about encryption. Mobile device management is an important one these days. Not really, wrapping the questions around that. You can have some issues on site when we're going out to image phones. MDM is also going to potentially allow you to gain access to different types of data that may be preserved in a cloud or a backup system. Now is starting to become a little bit more advanced with MDM solutions, where you might actually have a client, if you're on the attorney side, who is actually has a system to preserve text messages. Usually it results or involves locking down a phone, so you can only install certain apps, and then funneling all text messages through an SMS protocol. Always asking about email servers, right? People will be pretty bold and just log in and start sending things off, to their personal Gmails. Typically on a theft of trade secret case, usually it's going to be their personal email that they're going to log into. most employees are savvy enough to know not to email on their work email to their personal like Gmail, though we do see it. We're always looking to see if there's a policy in place on the email server side, whether or not that an employee can archive email or delete email long term. Certainly we're looking to see what type of cloud services that could be on a laptop. And it's important here to actually get an understanding of what is a company, a company like cloud, a company like Google Drive, a company, like Dropbox, as opposed to something that's a personally owned cloud storage. That's usually a huge red flag, is when an employee, is syncing their, like Google Drive or their personal, like OneDrive to their work computer. And then certainly, we're always trying to get a sense of, any like dates. When did you switch your email system? When did we actually, give access to an employee? What, like network shares did they have access to? Those are all important like questions. And then we want to get a sense of, what user activity we're going to be looking at. Asking about some of these baseline systems on the network share side, email server side. This will allow you to timeline things. You may not be just looking at an employee-owned device. It's also pretty common in more robust enterprises now. We're looking at like network activity, where there's logging, at the switch level and at the networking infrastructure level. So, as far as the custodian interview process, you usually want to, as far as a data map, also draw out a relationship map, and it's important to get a sense of who was working like with who. Part of that like process, as far as defining that like relationship, typically speaking, you're running about 30 to 45 minutes to like do these interviews, and we're asking a mix of work product like generation like questions, especially if you're outside counsel. You're trying to understand what is valuable. What did this employee do? What was their job function? All of those questions are very important. So, going into the more like technical things, just some immediate steps to preserve. We mentioned that you don't really want to wait with like digital evidence. You want to kind of try to get it as soon as possible. Certainly with a mobile phone, if it's powered on, you actually want to typically leave it on. There's more data that can't be like recovered. So if you ever, have your phone, it dies, and you notice that you turn back on your iPhone, you don't actually get notifications on the lock screen until you actually enter in your PIN code for the first time. Likewise, imaging, and when I say imaging, taking a forensic snapshot of a mobile phone, when it hasn't been turned off, there's more data that will typically like become available. Like what were the last apps used, right? It's those last steps when an employee leaves an organization that are typically the most impactful, right? That's when they're going in, they're like deleting things, they're copying things. It's those last couple days. If the phone's been on, you want to keep it on. So we usually will recommend that you try to plug it in, keep it online. Now, if it's off, keep it off. That's what I always tell people. You never know if there's been a wipe initiated. I've seen situations where an employee has installed like remote like wiping software on their phones and has triggered a wipe, more for Android. And then we want to image everything, right? So what did they have? When I say take an image, we want to use a forensic tool like Celebrate, Encase, FTK, for a cell phone, like Celebrate, but for a desktop or a network share, we want to go ahead and take a snapshot of those. So there's a lot of data that can be like recovered from computers. It's important to really get a sense of what applications are installed. Just kind of going and looking in the like shell tray or relying on an IT person who's at an organization where an employee has left to tell you what's been installed isn't really enough. People find ways to install their own, all of their own like software all the time. Certainly, chat content, Apple iMessage chats, Facebook chats, Skype calls, Skype chat messages, Skype file transfers, Skype voicemails. Like Dropbox is a big one. We always see people throwing stuff on a Dropbox. Google Docs, Google Drive, OneDrive, SharePoint, and then email, right? So we want to be looking at, any type of accounts that somebody could have had access to and pulling those out. You're not usually going to gain access to an account that an employee, like was using. Say if I'm going to leave Haystack ID, I log into our, Salesforce, I download everything, and I send it to myself via Gmail. Now, although I can't get to that Gmail, as now the employer, I can usually see the activity that somebody logged in, and there are like recoverable fragments, even when you don't have access to it. There's some forensic products that do a really good job of recovering pieces of like web-based email. So you can sometimes get that stuff. Mobile devices, obviously a robust repository, right? Everything's in our lives is on our phones, right? We used to, back in the day, you would, go and sit down and read articles on your computer. Now we just sit there on our couches, staring at a phone. And what typically happens is we find the most impactful information on mobile devices. Contacts, call logs, who's calling who. When was a contact added? Time frame is so important around these. We're always looking at timeline. Like voice messages. You never know. You have flagrant, like I've seen cases where we have a new employer leaving like messages for an employee who is still at their company, telling them to steal data and to bring it to their company, right? And that's the like kiss of death right there, is that, like collusion between a future employer, an employee at a company they're about to, in a company they're about to leave, when the new employer is directing them to, start to steal. This has happened to me at my own company, so it's pretty common. There's a lot of stuff on a smartphone that we can recover. Now, like location-based evidence is great. You may have a situation where, a sales rep who's stolen some information, usually a client list in the situation, may be meeting like with clients, right? They may be going out for, like interviews with a future employer, or like discussing strategy with a future employer while they're at their current employer. There's a lot of different places where we can get location-based data. I won't go through all of this, but you can see here that just tracking where you are is one of the easiest things to do now, like with a mobile phone and with like digital like forensics.
One thing to add on that, just so everybody's aware, even though you say don't track my location for some of your apps, they don't all listen. So there's a lot of location-based evidence that is being stored. Now, whether it's being presented to you or not becomes a question that you have some control over. But some of these apps that even when you say don't store it, it becomes the case. We recently had a case earlier this year for a Twitter investigation for a woman had her handle hacked, and the hack went like this. They took control of her account. They recycled her handle, immediately signed it back out, paid for, registered the account back under their name, and promptly started sending out some very ugly, offensive sort of tweets. But it all went out under her name, which caused her all kinds of trouble, both personally and professionally. We ultimately dug into that account, and through a series of analyses and investigations, we were able to find out that the new account that was sending out all of this ugly information was actually created in Yokohama, Japan. And that was all through this location-based evidence and sort of triangulating back onto that. So this is an important piece that is available in an investigation.
And just trailing on top of that, even turning off those location services, I mean, you are still being tracked, but another thing that's even is tracking you is your Wi-Fi. So there's a website called like Wiggle that basically records the location of Wi-Fi like routers, all around, typically like metropolitan areas. These guys have these high-powered antennas that basically log the unique MAC addresses of these routers. Now your phone, even when you're not like connecting to a Wi-Fi like hotspot, still logs it. It logs its MAC address, it logs its name, and there's a record of all of the Wi-Fi hotspots that you sniffed, so to speak. Using this website plus data we extract from your phone or computer, we can easily, like map out where somebody is. So it's another spot that a lot of people aren't aware, aware about. And I encourage you to, log into this website. It's called Wiggle, and I'm sure you'll find your own home's internet router on this website. So it's pretty amazing how that we cross-correlate data between multiple devices like that to paint a picture. And that all wraps around a timeline, right? So, putting facts around a timeline is always going to be pretty critical. Usually we're looking at the last 60 to 90 days before there's been an event, so to speak. And we have tools that will easily create these types of timelines. So there's a pretty typical process that these events follow. We have an employee who leaves, we image their stuff, we find they've done something. Usually, especially if there's a flash drive or a hard drive, we want to get that hard drive returned to us. And you always want to wrap that obviously around a legal hold notice, an intent to preserve. Because what happens is as soon as an employee, or I guess ex-employee, leaves a company and they get one of these letters, they typically try to start wiping everything. Now, it's very, very important that when you actually, send out a demand letter or a letter in the first place to say, hey, we have a problem here, you really are using strong legal hold language to just remind them not to delete anything, because that's going to be a trickling effect downstream. People don't typically engage counsel, right, the first day, and they start to blow everything away. So yeah, a demand letter, getting back that flash drive, that thumb drive, getting a forensic image of that device, a letter to the new employer saying don't use our information is critical. Then we usually go for the TRO. And then as soon as we get that hard drive back, right, that's when you're starting to say, okay, this is the information that you took. Here's why it's valuable. And as part of this process, if we know that this information's been accessed, there's been an access date, there's a change there, where typically we'll start to go after the new employer now. And we want to see all the devices that were assigned to that, the new employee who had left the previous company. And we're looking to do an investigation on those devices to see if any data has been copied, from that hard drive, or if they've logged in to, their home Gmail and downloaded an account list onto that new device. So this is a real common way that we're looking to kind of extend the scope of an investigation to get full-blown remediation, which can oftentimes be, getting another third party to go into the new co to start to do a forensic deletion exercise, or just to assess risk, and it's a payout in the TRO. So just some reasonable hotspots that we're going to look at when we get, a laptop that a departed employee used at an employer that they left. We're going to look at all the user accounts, all the email accounts. We're going to look at all the software installed on a computer. You always check to see if they had CCleaner. That can be a red flag, something to wipe data prior to, them leaving. Looking for deleted data oftentimes will show intent. What are people what are they deleting before they leave? We've had cases where somebody has gone in and deleted an entire network share. That's just as bad as stealing, right? And it makes it very difficult to say what was stolen, and that oftentimes will turn into a full investigation, at their new employer if we think there's reasonable risk that they did steal something. Anything where somebody has copied anything, you can never see exactly what somebody has copied, but you can see when that they opened something. We can see the windows that they opened. When did they plug in a flash drive? Okay, then you access 10 files in fast succession, and then there's a link file to show us that you copied this here. It's more of painting a picture around what data has been copied. It's a question we get asked all the time. Can you say for sure that this has been copied? No, not unless we have the device that something should have been copied to. Then we can. And just going through all of this. So we actually offer a package, a Haystack ID. It's the departing employee investigation package, and we'll analyze a cell phone, any email accounts, and up to 2 laptops for about $3,000 dollars. All in one, you get a pretty nice report that includes all of this. This can be good if you just have a high-risk employee where you don't think they've actually done anything, or maybe they have, or you're just, you are like concerned. You're not spending a ton of money to go into a complete investigation, but it's enough to get that low-hanging fruit, to pull it out, and to usually know if there's been bleed.
So when you go to the court with you found the offenses in your own system, you want to take that evidence to the court because it's going to buy you a lot of favor with the court when you're seeking to have them have the defendant take action. So if you have found specific documents or things like that, you can then go to the court, and the judge is a lot more likely to approve using specific search terms or specific devices, which would be image, because you actually have somewhat of a roadmap to assist in that process. So you would, when you're seeking an order from the court for this, you would specify the devices and accounts that you want to have imaged for examination. You would limit the date range and the keywords to the documents that you had found in your proprietary equipment. And you would subject that to a privilege review process. And the keyword responsive review and production processes. So you would subject this stuff to your basic review like you would in any document production, but you would limit it to scope to where you're likely to find relevant things. And that's a way to strike a balance between the individual's privacy, and because you're looking at their personal life as well. And limit to the scope of what's really at stake. Okay.
Right. So, the challenge on trying to move to the offensive is generally you're going to be accused of a phishing trip, right? Judge, they don't know what they're looking for. They just want to start poking around. There's no specificity here. There's no proportionality here. Can drop all the buzzwords that are out in the space right now. So really, as Drake just said, you can rely on collecting your own devices, because remember, communication's a two-way street, right? Nobody's talking to themselves. And if you can find evidence or suggested evidence around that there was a communication that took place there, and you can present that to the court in a compelling argument that says, I now need to see the other side of this communication. You can see the whole thread here, but I want to take a deeper look because this would certainly smells fishy. Then you're in a much better position to be able to give that judge, frankly, some cover to go ahead and approve that motion. And let's be real, that's having cover matters, right? So we do a decent amount of pro bono work. We do a lot of work with the Chicago Legal Defense Fund. And one of the things that our examiners find frequently is evidence of spying or bad behavior. And a lot of these cases involve discrimination and harassment and stalking. So people behaving very badly and potentially very dangerous situations. So things like email forwarding, tracking my iPhone, and putting spyware or key logging software onto phones happens pretty frequently in these cases. And so there's a couple ways we get around that, but I mean, certainly for email forwarding for your Gmail account, it's buried a little bit deep into the account settings menu, but if you know what you're looking for and someone gets up to go to the bathroom for 5 minutes, by the time they get back, you could have set it up so that every email they receive is now also being forwarded to you and they would never see it. Think of it almost as a BCC. Track My iPhone, same kind of thing. You can turn that on and have it track that iPhone's location and send you those coordinates so that if you were so inclined to stalk somebody, you would be able to know where they are. And then, key logging software, again, it's kind of like the scam that's going on around town right now with the ATM machines where it's all built in, same kind of deal here. So there's a couple of things we do around that. And this is probably less, this is decidedly less prevalent in our commercial practice than it is in our pro bono practice. But we have a physical access questionnaire that's really pretty basic. And it's asking questions like, was there a time, at what point in time did you not have physical custody of your phone or your computer? Was there a time when the target of this investigation may have had unfettered and unobserved access to that and to those devices? And if the answer turns out to be yes, then it's something worth looking at. And if we find this, and we have found some before, we have found one actually in a domestic violence case, and the now ex-husband, who is a guest of the state of Illinois at this point, but he had put email forwarding in, and the wife had been corresponding with her counsel for weeks about how to make this all work, working with a support network about how she could get away and things like that, all via email. And it was all being forwarded directly to the abusive husband. And so when counsel found out about this, in terms of, we reported back that this was going on, and the light bulb went on for counsel in terms of, so they've been reading all of the privileged and protected email and communications we've been having with our client. The answer was yes. So there's a couple of things we can do around that. To retain that privilege and that confidentiality, we generally suggest that you reset your devices, factory reset. Mike did a session yesterday about smartphone forensics specifically, and there was a lot of talk about, well, how do I kind of clear my phone, right? Well, factory resetting your phone is a great way to do that, right? Because then it's all gone, including any malware, spyware that may be there. Certainly, take a look at your computers to be able to do this, or have someone like us to come in and do that. And then as far as communications go, while that's taking place, go to a known safe computer, like one from work, to handle those communications. And then ultimately, when you get a new computer, wiser, a little more jaded, a lot more cynical about how evil the world can be out there. You can take the appropriate steps at that point.
And with smartphones too, typically speaking, with Androids, that's where you actually could have more of a type of virus or some type of Trojan-based, like surveillance, like application installed. Apple's pretty good about not allowing you to install an unauthorized app. But with Apple, what you're going to find there is that their iCloud account like credentials, or just their Apple IDs will be like compromised. I see that a lot where somebody knows somebody's like Apple ID, and they go down and they pull a backup of their phone down. We've had several cases like that pop up even the last like 2 months,
Right.
where a third party has gained access to somebody's like iCloud, and it's pulled out a backup of their phone to gain access to their device.
Yeah, because think about it. If you set up that trust way back when you got your first iPod, right? And you built that Apple iTunes backup, and you set up a trust between your computer and the Apple device you're charging on that computer, then that trust is also saying, make a backup of the content of this thing that I'm charging up to my cloud, which is your phone. So I go get a new phone, I download from my iCloud account, I now have all my old content. It's great for moving phones. It's also really great for stealing stuff from your former employer.
And just for yourself too, right? Imagine how long you've had an iPhone for. It can be pretty scary to go back up there and see, like what you had saved in the cloud from 10 years ago. So I always recommend that people get a hold of those accounts sometimes. Just go take a peek at what's up there, because something can always come up that you didn't expect that you had saved up there. And that's the big thing now with all these Apple-like devices and the cloud, so to speak, is your replication of your personal data
Absolutely.
is just everywhere, right? So I send in a text message on my iPhone, and now it will sync to my MacBook, right? And you delete it in one spot, but still on your MacBook or your iPad. So it's certainly something to be aware of. And I oftentimes, will like recommend, if you're working in a job or something where you're just trying to, you're trying to like separate, like your work and life, always create two separate, two separate Apple accounts, one for your work life and one for your personal life. And that's a great way to prevent the type of commingling of your personal data and your work data.
Yeah, compartmentalize your lives. But the other piece on these, unlike iCloud, for example, is it means I don't necessarily need that phone. And we have done cases where the phone is not available. But we were able to get the Apple iTunes username and password and iTunes backup password, which means I could go to the cloud and I could not only get the current phone, more importantly, I could get every prior phone that had been backed up to that. And in the case that I'm referring to, it actually was a phone, an iPhone 5, so it's several years old, that was being used by the target of this investigation during the time frame, several years ago, that this investigation was looking at. And this person had maintained that phone is long gone, I've recycled it, it's all gone, no way I can get back to that data. It was there. So there's a lot of ways to be able, like I said at the top of this, everything you do on a computer generally will leave a breadcrumb. So,
Any
it's easy to follow.
questions?
All right, thank you very much for coming, y'all, and yeah, enjoy the rest of the show, Innovation Awards, and the closing ceremonies.
Safe travels.
Yeah, and since nobody's local, everybody travel safe home.